exit out of the.
Okay, so good morning, everyone. Thank you for being here this morning. The weather is getting better, so that's good. I like it. So we are the Minority Business Development Agency Business Center, and we are pleased to bring to you another webinar, Employees versus Contractors. And I just want to this morning introduce, we have the pleasure to have the SBDC also with us today. So please, Fran, go ahead and introduce what SBDC does for small businesses.
Sounds good. Thank you. Thank you, Sophia. Good morning, everyone. My name is Fran Fernandez. I am the director of the Small Business Development Center at Central New Mexico Community College. Just want to take a couple minutes to share with you what my organization does to help small business owners in the community. The New Mexico Small Business Development Center program was founded in 1989. We've been serving small business owners across the state for 34 years now. We have 18 small business development centers across New Mexico, and a highly skilled staff is comprised of 63 business professionals that have business management experience and business ownership expertise. We are funded in part by the Small Business Administration and the New Mexico State Legislature. And we operate through a cooperative agreement with Santa Fe Community College to provide services to small business owners in our community. Our mission is to develop skilled entrepreneurs and strong businesses in our state. The Small Business Development Center at CNM provides counseling and training services to help small business clients start their businesses, to grow their businesses, and most importantly, to stay in business. Some of our client services include our no-cost confidential business counseling to help clients at all stages of business development. We provide technical startup assistance to help our clients from just getting started to working through the plan so that we help ensure client success. We also review available funding options and help assess the best options for our clients. We provide technical startup assistance to help our clients understand the steps of starting a small business in the state. And we do work with existing businesses as well to help them continue to thrive and to grow. We can also help our clients access market and industry research as part of the planning process. And we have several tools available. And we also offer bilingual counseling and support services to help our Spanish-speaking business owners in the community. To help our clients become skilled entrepreneurs, we do offer a low to no cost business education workshops and trainings through our online training portal. There's many advantages to working with the SBDC at CNM and our community partner, the Minority Business Development Agency. As we all are invested, we really want to help you and your business succeed. So I encourage you all, please visit our website at www.nmsbdc.org to learn more information about our program. And you can register for services and their counseling and training services there online. You can reach us at our main number or simply send us an email. We're always available to help you with your business needs. And so with that, I want to introduce to you our esteemed speaker this morning. Her name is Christina Cavallari. She is with Law for Small Business, and she's going to really uncover the truths behind employees versus contractors, that topic that seems to be on a lot of folks' minds. We really want to get some clarification on that. So with that, go ahead, Christina, go ahead and take it away. Thank you.
Thank you so much. I'm so excited about all these wonderful programs, and I'm so happy to be here. I will start sharing my screen so you can see my presentation. Share. Okay. All right. And someone will let me know if that didn't work. Otherwise, I'll assume it did. So welcome to this webinar. My name is Christina Cavallari. I'm an attorney at Law for Small Business, which is a firm that's available in multiple states, but we're headquartered here in New Mexico, and we are excited to offer services to small businesses throughout New Mexico and throughout the United States. Sometimes we even serve small businesses with international contracts or, international businesses. So today's topic, contractors versus employees. If you're here, you are probably already aware of kind of the basic differences between employees and contractors, but I am going to just kind of start at the beginning. And so this can be a total beginner's guide, and I hope that I won't be too boring for most people. Next slide. There we go. Again, let's see, a little presentation guidance that I don't think is relevant to a webinar. But if you do have questions, the final 15 minutes of this presentation is reserved for questions and answers. I'm going to do my best to stick to that, to leave plenty of time for questions. And then if you write down your question and the slide number that it relates to, or just write down your question and submit it in the chat. There was already an invitation in the chat to submit your questions. All right, so what are we going to talk about today? I'm going to hide myself so I can see this slide. First, how to tell the difference between an employee and an independent contractor. How to tell whether you need an employee or an independent contractor. And as I was making this presentation, I realized that I tailored it towards employers. But an interesting thing about employees and independent contractors is that small business owners, especially if you're a sole proprietor of a business, you may end up being an independent contractor frequently to other businesses, especially if you sell services. So this presentation, keep in mind that you may, even as a small business owner, end up asking yourself, am I an employee or am I an independent contractor? And if I'm intending to be an independent contractor, have I accidentally become an employee for things like branding or liability? So we'll talk about that a little bit too. Or how to tell whether you need an independent contractor or an employee, or if you already have one. Or if you are one. And then we're going to go over what are the good things and the bad things about each type of worker status. This is the disclaimer that I have to give as an attorney. I am an attorney. I'm not any of your attorneys because I haven't met you. I would love to meet you if you do need an attorney. So this material is presented for informational purposes only. It's not legal advice or tax advice. Oh gosh, it's not tax advice. You're encouraged to consult with legal counsel or a tax advisor of your choice. We will talk about the law and taxes. This presentation does not create an attorney-client relationship between us or between you and my law firm, or any law firm that I'm employed by or associated with. Okay, so if we were all together in a room, this would be when I would have us brainstorm. So that's a little picture of brainstorming. What we think about when we think about employees and independent contractors. But since we're not all in a room together, I did it for us. So I brainstormed on my own, some things that I think about when I think about employees and things I think about when I think about independent contractors. So employees tend to be permanent or long-term. They tend to be loyal to your business. Your business might be their only job. You tend to train them. They tend to be pretty reliable. And if they're not reliable, you might replace them with other employees. They tend to be available to your business and for your business's needs. You know their insurance risks. You know as an employer that you need to insure against any thing that your employee might do. And your insurance policies, your business insurance policy usually covers liability that arises from an employee. You as the employer has a high level of control. As the employee, you are directed pretty specifically by your employer. And then generally, your employees get a W-2 to show the compensation that they've been given. For independent contractors, frequently you'll hire an independent contractor temporarily, or if you have a need for them. They frequently have multiple clients. You're just one of them. They usually come with a special skill set, so you don't have to do as much training. The hiring business is not responsible for payroll, taxes, workers' comp, or unemployment insurance. And that's one of the big differences between independent contractors and employees, right? Is that when you hire the independent contractor, that number on your contract is what you pay them. You don't also have to pay all of those other things that come with having an employee. They should need a lesser degree of management. Sometimes that's not true. It kind of depends on what you're hiring them for. They can frequently provide services that are outside of your business's wheelhouse, like tech support or graphic design or construction services. They can be self-insured, and that's something we'll talk about. It's important because you don't have that known insurance risk. Your business insurance policy might exclude them from your insurance. So it's frequently an independent contractor contract will include who bears that insurance burden. And their compensation is usually reflected on a 1099. Okay, so now we'll ask, what does the law say about it? Because I'm a lawyer and that's what I'm here for. So an employee, per the unemployment compensation law, and this is important, where we talk about whether someone is an employee or an independent contractor is in the realm of, are you paying taxes correctly? Who should be paying the employment taxes? Your business or the independent contractor's business. In unemployment compensation law, when someone loses employment, are they going to be able to claim unemployment benefits through the state? And then the other place where we see it, is if a worker has caused harm to someone else, whose insurance or which company pays for that harm? And the tricky thing about telling you the difference between an employee and an independent contractor is that those three areas, taxes, unemployment compensation, and torts, which is injuries to other people, those all have different definitions of what an employee is versus an independent contractor. So we're going to go through that in the presentation, but if you're finding that, Christina, you just told me one thing, and then you told me a completely different thing, you're not crazy and you're not listening. It is different for each of those three contexts. So for unemployment compensation law, which is if New Mexico Workforce Solutions is going to come after a business owner, or if you have found yourself in a position where you've been terminated from your work, it's going to be important whether you were an employee or an independent contractor, and it's not necessarily going to be just determined by the contract you signed with the business. So per the unemployment compensation law, which will determine if you can go to Workforce Solutions and get unemployment benefits, employment means any service, including service in interstate commerce, performed for wages under any contract of hire, written or oral, express or implied. So this is very broad. This applies to everybody who's doing work, right? It applies to employees and to independent contractors. So now we're going to narrow it. So we've skipped, you saw one, we skipped 2, 3, and 4 because they weren't relevant to this definition of an employee. But so the services performed by an individual for an employer for wages or other remuneration, unless and until it is established by a preponderance of the evidence that. So now we're going to carve out independent contractors from employee. So they just established that big category of work, and we're going to leave that big category as employees. And now we're going to carve out a little bit for independent contractors. So the individual has been and will continue to be free from control or direction over the performance of the services, both under the individual's contract of service and in fact. So this is the control part. If an employer or a hirer has hired somebody to fix their computers, that person might be able to just fix the computers in any way that they see fit. And their contract says, I'm hiring you to fix the computers. This is the amount I'm willing to pay for this. That's the end of my control over you. And then that person has come in to fix the computers, and the person who hired them isn't saying, well, also I'm going to need you to wear this shirt. And I'm gonna need you to come in from 8 to 5:30. And I'm gonna need you to be here in case any computer breaks. So you can see how this control and fact part can sneak up on you, even if you have a contract that says you're not controlling the worker's work. So the next part is the service is either outside of the usual course of business for which the service is performed, or such service is performed outside of all the places of business of the enterprise for which the service is performed. So this is you can do one or the other. So if you're hiring somebody to fix your computers and you're, say, a law firm, your usual course of business is not fixing computers. And so that one you can satisfy that way. Now, say your business is fixing computers, but you've hired somebody to go fix computers at a different place for some reason. And that one, you just need to make sure that you're avoiding the amount of control that you would have of an employee. So then C, the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the contract of service. So this is helpful if you say, one of my good friends, he has a computer service repair and service business. He has a lot of clients, he has a website, he has an office space. And so he is an individual who's customarily engaged in an independently established trade, occupation, profession. This as the same nature is involved in the contract of service. So if you hire my friend Josh to fix your computers, it's more likely that he's going to remain an independent contractor because he already has a computer fixing business. So then we kind of already went over this. What is an independent contractor? It's essentially not an employee. So everybody who's doing work for money is an employee until you carve out independent contractor from it. So the relationship cannot fit the legal definition of employment. If you're an employee, you cannot be an independent contractor. So I work for Law for Small Business. I'm an employee. Law for Small Business can't have me be an independent contractor also for the same role that I have, which gets confusing in the modern work economy, especially for millennials and Gen Z. All of us have multiple gigs. You know, everyone's got a side hustle. So, and some of us are even doing side hustles for our main business because it's hard to find someone, and a lot of people have a lot of talents. And so you might have an employee who you want to hire as an independent contractor because they work for you Monday through Friday doing clerical work, but they also moonlight as a graphic designer. That can be done. You just would have to be super careful because you already control them in fact. So you need to make sure that their contract is really different from their employment. It can't be at the same time. It's got to be different kinds of duties. So it is possible that one worker will be wearing multiple hats for your business or for multiple businesses. So this slide, we just went through that statute, and my question is sort of, even though I explained it to you in sort of painful detail, and it doesn't actually get easier. You might have heard of the ABC test, and the ABC test is what most courts use to determine if a worker is an employee or an independent contractor. The ABC test, the funniest thing about it is that there's no A, B, or C. So it refers to subsections A, B, and C of a statute. I would hear about the ABC test and look for, I thought it would be, the C would be control, the B would be behavior, the A would be, but it's not, it's 3 statutory sections. So A is that the individual has and will continue to be free from control or direction over the performance of the services. So the C that I thought was control is actually A. So this is the test, the federal courts, the New Mexico state courts. The IRS has a 20-part test that they have. President Trump adopted a new rule that replaced the 20-part test that was more like the ABC test, but it was a little bit disfavorable to employees. And so President Biden repealed the change that President Trump had made, but it left the 20-part IRS test a little bit less useful. The IRS probably won't follow it. What the IRS has tended to do is defer to the classification under state law. So the A of the ABC test is control. An independent contractor will not be controlled or directed in the performance of their service, both under the contract and in fact. They will only be controlled in terms of the outcome. So you'll hire my friend Josh to fix your computer. You won't tell my friend Josh how to fix your computer. So it's not enough to have it just in writing. It has to be real, real lack of control. The next part, the B, is subsection B of that statute. The service is either outside of the usual course of business for which the service is performed, or such service is performed outside of all the places of business. So you can't have an independent contractor working the cash register at your store. You can't have on-premises sales staff of independent contractors, and we'll talk about a New Mexico Supreme Court case from 1986 that is a little bit funky, because you do have, this company did have sales staff, but because they weren't on premises, they ended up retaining their independent contractor status. And you say, well, what about when I go to Costco and people are giving out samples of that Dave's Killer Bread, their sales staff on premises, but those salespeople are typically engaged or acting on behalf of Dave's Killer Bread or whichever manufacturer or vendor is trying to sell their products at Costco. So one thing that helps in independent contractor versus employees to buttress that distinction is that if someone says, well, aren't you an employee of Costco? That person can say, no, see, here's my W-2 from Dave's Killer Bread. And so if you can show that you are acting in the scope of employment for someone else, then that makes it easier to retain the fact that you're an independent contractor for Costco. The third test, and this is where my friend Josh has an office for his computer repair business. He has his business cards, he has a website. So this is the person is customarily engaged in an independently established trade, occupation, profession, or business. Electricians, plumbers, and tradespeople easily clear this hurdle. Owner operators pass this hurdle. When in doubt, look for case law, which sometimes makes the issue more confusing. But we're going to go to the Fair Labor Standards Act. And this is a federal law that addresses other matters in employment law. And so this is another good place to look for who's going to be considered an employee and who's going to be considered an independent contractor. So it has 6 parts. So this one is the extent to which the worker's services are an integral part of the employer's business. Now, this is a little bit different. What we did already was we went through the workforce solutions test, which was 3 parts, and they were the same 3 parts twice. They were the ABC test. This is a little bit more nuanced. So this one is saying, how important is this worker to your business? And this is where the best examples are probably where employers are doing a bad thing. And what I think of is hair salons and spas. And if you're a hair salon owner or a spa owner, I'm not calling you out. Well, I guess I am calling you out a little bit, but I am telling you, you need to be careful of this. Because if you think about what is the business of a spa? A spa is offering customers spa services like facials, massage. And so your business might be a spa, and you might have hired your facial therapist or your massage therapist to be independent contractors to perform those services for your clients. But you may end up in a situation where the question is, well, what is your business if not offering this person's services to your clients? So if this person's services to your clients are an integral role in your business, performing the primary type of work that your business performs for customers or clients. And so that will tend towards classification of an employee, even if you intended for them to be independent contractors. So your independent contractor agreement has to be pretty robust to do that, and your control over these folks has to be pretty limited. And then my question would be, what are the business purposes that you're trying to achieve by classifying these folks as independent contractors? And that might change your mind about how you decide to continue to classify them in the future. So that's a little bit different from the ABC test, but it kind of is a species of control. The permanency of the relationship, how long has the worker worked for the same company? If you have a person on staff who you are treating as an independent contractor, but they've been on staff with you for 10 years and you're their only employer, then you might want to consider if you actually have an employee. The third one is the amount of the worker's investment in facilities and equipment. And this is a good example. If the worker is reimbursed for everything that they purchase for the business, and if the business has bought them all of the equipment that they use, that will tend towards that worker being an employee rather than an independent contractor. Okay, so then fourth one is the nature and degree of control by the principal. We've already talked about that. That's A in the ABC test. So that's still here. The worker's opportunities for profit and loss. This one, an independent contractor will be more likely to benefit from company, or my computer is yelling at me to plug it in, so I'm gonna do that real quick. Okay. Okay, I hope that didn't majorly. Host will jump in if it did, I'm sure. Okay, one moment. I am having some technical difficulties. We might have to switch. Okay, please jump in, hosts, if you can't hear me. Otherwise, we're back in business. So we were on number 4, the degree and nature of control, that's the A. So now to number 5, profit and loss. An independent contractor will enjoy more profit from more business opportunities. Say one of my friend Josh's clients grows and hires him to do more computer repair, he will make more money. If he were an employee of that growing business, he would continue just to make his same wage for his full-time employment. So that's a good example of how that difference plays out. The level of skill required in performing the job and the amount of initiative, judgment, or foresight in open market competition with others required for the success of the claimed independent enterprise. Again, this is how much does the employer or the hiring business insulate the worker from the market. So most employees are going to make the same hourly wage or salary, whether the business is doing really well or doing really poorly. And the employees' initiative, judgment, or foresight in open market competition doesn't really play into it. That's the boss's role. And here again, we already talked about, does the worker advertise independently via Yellow Pages, have business cards? Does the worker have a separate business site? Those will all help a worker not to be considered an independent contractor. So now we'll go to the IRS, because we were talking, first we went New Mexico state law. Then we did federal law, but for the same purposes of employee protection. Now we're going to go to the IRS, and this is for taxes. Because one of the things you probably are already aware of with independent contractors versus employees is that if you have misclassified someone who is your employee as an independent contractor, the IRS can come after you for all those payroll taxes you didn't pay. So that's Medicare and Social Security and a few other taxes and fees. So the IRS used to use that 20-factor test. Now they consider the ABC test pretty much. Behavioral control, financial control, that's the A. The type of relationship of the parties. And that's sort of the B and the C. So behavioral control, they'll look at the instructions that you've given to your worker. They'll look at the training that you give to your worker. So instructions will be schedule, like if you told your worker exactly what their work hours are, what they're supposed to wear, how they're supposed to do their job, they're probably going to be an employee. If you've trained this worker extensively, that tends toward them being an employee rather than an independent contractor who usually comes with their own training skills and methods. Here are the examples that the IRS gives of the types of instructions about how to do work. We talked a little bit about when and where, what tools or equipment to use, what workers to hire to assist with the work, where to purchase supplies and services, what work must be performed by a specified individual, or what order or sequence to follow. So these are just more sort of intuitive examples of what would be control. The amount of instruction needed varies among different jobs. And this is an interesting one because frequently an independent contractor will be hired to do something, especially in high-tech jobs. You might have an independent contractor who needs a great deal of being brought up to speed on your system. And so you might have a harder time establishing that your genuine independent contractor is an independent contractor and not an employee. And so you might make the choice to hire someone on as an employee that you otherwise would have as an independent contractor, or you might make the choice to take the risk and to be willing to argue to the IRS that no, in fact, this is a highly skilled professional and this is a highly complicated project. And so they did need a lot of training, but they did retain the right to control the details of the job. Financial control. So an employer has a lot of financial control over employees. When you think about, most employees aren't really even usually issued a company credit card. And so most employees, if they want to spend company money, they have to submit that to the employer. Additionally, the employer sets the time and the amount that the employee is paid. Now, the employee can negotiate that at the outset, and the employee can always choose to leave. But an independent contractor will be able to accept one project at one rate, and then, you know, they're their own business, so they can choose to contract with you again or not, and they can choose to change the amount that they're willing to contract with you for. So that's the financial control. Again, an independent contractor often has significant investment in their own tools or their facilities. My friend Josh, he has his own tools, he has his own office, and so that's what they're looking for. How much is the independent contractor's business separate from the potential employer or the hiring business? And then this one is that non-exclusivity. So an independent contractor, something that weighs heavily in favor of someone being considered an independent contractor, is if they're offering their services to multiple clients. And this is the part where you might have heard that you shouldn't have a non-compete in an independent contractor agreement. If you haven't heard that, you're hearing it now because of this part of the common law rules. If you require an independent contractor to promise that they're not going to provide their services for anyone else, they're probably an employee. So if you want to protect your clients from your independent contractors, it is more palatable to the IRS and then to the Department of Workforce Solutions to have a non-poach rather than a non-compete. So that you're not telling the independent contractor that they can't do their business, but you're telling them that they can't do it on your clients. How the business pays the worker is another thing that the IRS will look at. If you're paying your independent contractor an hourly, weekly, or monthly wage or salary, that's more likely to be an employee. Usually independent contractors are paid on a flat fee for a project, or even in professions such as law, they're paid hourly, but they'll send you an invoice, and the invoice likely won't be the same amount every month, because it'll depend on how many hours they've worked. And then the extent to which a worker can realize a profit or loss. An independent contractor should be able to make a profit or loss because they are their own business, whereas your employee really shouldn't be making a loss on their employment. Okay, so the type of relationship, this is when we look to the written contract that you have with your independent contractor. If you have no contract with your worker, you probably have an employee, because it's a lot more typical to have an employee without a written contract. If you have a written contract describing the relationship, it's probably an independent contractor agreement, and that will be one factor in determining if you actually have an independent contractor. Whether or not the business provides the worker with employee type benefits such as insurance, a pension plan, vacation pay, or sick pay. Employees tend to get these things. Independent contractors tend not to get these things unless they're employees of their own business. Again, this permanency of the relationship, if your independent contractor has been with you permanently for multiple years, that will tend towards them being an employee. Here's this key aspect of the regular business of the company. So you see that there's a lot of repetition between the ABC test and the 6-factor test from the federal government and now the IRS. Here's an example. Rose Trucking contracts to deliver material for Forest Inc. at $140 per ton. Rose Trucking isn't paid for any articles that aren't delivered. At times, Jan Rose, who operates Rose Trucking, may also lease another truck and engage a driver to complete the contract. All the operating expenses, including insurance coverage, are paid by Jan Rose. All equipment is owned or rented by Jan, and she's responsible for all maintenance. None of the drivers are provided by Forest Inc. Jan Rose, operating as Rose Trucking, is an independent contractor. So Forest Inc. needs some stuff delivered. They go on Google and they look for a trucking service. They find Jan Rose. They think her trucks are pretty. They think her prices are fair. And so they contract for her to deliver their freight. That is a very pretty easy example of an independent contractor. But that is the example from the IRS. So this 1986 Supreme Court decision is one of the few New Mexico published cases that talks about the difference between an independent contractor and an employee. It's 1986, so the whole scheme of work has changed a lot since then. So it's kind of, I'm going to go through it fast because I don't know that this would turn out the same way today. But so it's a solar company. They employed a sales force. The sales force, think less like salespeople at the furniture store, the department store, and think more like Death of a Salesman, Willy Loman. So these folks were traveling salespeople selling for this solar company. They made only the money that was over the company's wholesale cost. So if they sold solar panels for above the wholesale cost of the solar panels, that was what they made, probably after a percentage for the solar company, in order for the solar company to be profitable. But their entire compensation was based on the difference between the wholesale price and the total price that they made the sale for. The solar company didn't dictate the hours during which the sales had to occur, the means. They could go telephone, they could go door to door, and what techniques the salespeople used. The sales didn't occur at the solar company's place of business because these are traveling salesmen. So they're out on the road selling these solar panels. And the salesmen, again, think Willy Loman, they could sell whatever they wanted. So they might be selling solar panels and they might also be selling vacuums. Maybe they're selling Cutco knives. And so all of this said that these salespeople were independent contractors, and the court did use that ABC test. So does the rationale still apply? Arguably yes, arguably no. It's very different now than in 1986. My concerns are that in 1986, businesses had a much more specific locus of business, whereas now businesses are so much online and sort of operating in a conceptual space. So I don't know that I would recommend to a client to structure an independent contractor relationship exactly like this, because it's a foolproof way to have an independent contractor. But there are some, it's a good example of the ABC test in action, I guess. So now, if you do decide or realize that you have an employee What are your obligations? And a lot of you probably already engage with this, but you have to withhold your payroll taxes. So those are, and you have to remit them. So that's the employee's federal income tax, state income tax, the employer portion of Social Security and Medicare taxes, and then also the employee's portion. But you have to pay your portion and then withhold their portion and remit it to the IRS. Workers' compensation is assessment fees. And then you have to obtain workers' compensation insurance if you employ 3 or more workers, including owners and family members. And that's very important because if you have a worker who's injured on the job and you haven't done this, it can be very costly. Must pay into the federal and state unemployment insurance schemes. And that's again where Workforce Solutions and that federal statute come in. Must adhere to minimum wage, overtime, and other wage laws. Must comply with OSHA, the Americans with Disabilities Act. So OSHA is Occupational Health and Safety. The Americans with Disabilities Act is for Americans with disabilities, making your place of business accessible and making reasonable accommodations for your employees, and then the other employment laws. So both the federal and state governments have a vested interest in proper employee classification. If they find out that you've done a pattern of misclassifying employees, so I've had this experience in art small businesses where I think it was one 1099 misclassified worker did something really stupid with their taxes and got the IRS's attention. And so then the IRS looked at the 1099s that arts organization had issued to everybody, and then determined that the arts organization had misclassified a bunch of people as 1099s. It had a bad outcome for the people who were the 1099 independent contractors because they were all audited and required to pay their self-employment taxes. And the organization that had hired them was also in trouble because I think the IRS did determine that they had misclassified some folks who should have been employees as independent contractors. So the government really cares. And they care if you've classified someone as an independent contractor who should have been an employee. They don't care so much if you want someone to be your employee who could have been an independent contractor. Okay, so now insurance and torts. And I need to do these real quick. With torts, it's going to be a whole nother standard because torts are going to come from agency law. Torts are like if someone slips and falls in your business, or if you're a hospital and a doctor does medical malpractice, that's all tort law. The person who's injured is going to sue your business and you're going to say, oh, no, that wasn't me. That was my independent contractor, sue them. And the person is going to say, I went to Presbyterian Hospital emergency room to get my leg fixed and you did surgery on the wrong leg. And I don't care if your surgeon was an independent contractor. I was at Presbyterian Hospital. The New Mexico courts agree with that. And it's under something called a parent agency. So even if you've tried really hard to insulate yourself from your independent contractors, if it looks to the general public like an independent contractor is your employee, then you will likely have risk for being held liable for that person's actions. So if that's your goal, it might be better just to buy more insurance rather than to try to say, no, that's not my guy. Because that guy is wearing your uniform and has your badge. You can insure against the actions of independent contractors. You just have to make sure that you have a good relationship with your insurance broker. We talked about vicarious liability, and this whole PowerPoint is going to be distributed. So I just said all of this really fast. You can face liability for a theory of negligent hiring, retention, supervision. There's a horrible case in Texas right now where a FedEx driver, it's awful, but he ended up killing a little girl who she was playing in her front yard, and the FedEx driver hit her and then panicked and took her into the truck, and then she did end up being killed. FedEx is saying that the driver was an independent contractor. Her attorneys are going to argue that FedEx still should have done a background check on this independent contractor, knowing that their drivers would be driving through residential neighborhoods where there will be children. And so you still could be liable under negligent hiring, retention, and supervision for independent contractors. Reputational fallout, again, that's kind of like the Presbyterian Hospital independent contractors. If one of your independent contractors is doing a bad job, that's going to reflect poorly on your business, whether they're an independent contractor or an employee. Firing an independent contractor or an employee is about the same, an independent contractor arrangement. Let's see, that's our Q&A. I might switch right to questions. There we go, Q&A, because I see that there's one in here. What would you say is the benefit of having an independent contractor versus having an employee? Similarly, what would you say is the benefit of being an independent contractor versus being an employee? So most people will say, a lot of people will come to me, and especially in small businesses and nonprofits will say, I need someone to perform a service for me. I need someone to teach these dance classes at my dance studio. I can't afford an employee. That's usually why people end up hiring independent contractors, and it's the wrong reason. Just because you can't afford an employee doesn't really mean that you can just replace it with an independent contractor. But that is why most people end up with independent contractors, is because they want to shift the burden of the employment taxes onto the worker, which the worker can't afford that either. The more legitimate benefits of having an independent contractor is that a lot of folks, sole proprietors and small businesses, sell services, and they sell services to other businesses. And so if you're like my friend Josh, who sells his computer fixing services to other businesses, he doesn't want to be the employee of those businesses. He's self-employed. And so he's going to always want to be an independent contractor because he has his own business. Similarly, what would you say is the benefit of being an independent contractor? Being your own boss is great, especially if you're entrepreneurial. Then that's a great benefit to being an independent contractor. Also, if your industry, like massage therapists and computer repair folks, some industries are just customarily employed as independent contractors. So you might have picked one of those fields to go into where you end up if you want to work, you have to work as an independent contractor. I saw that someone had their hand raised. I don't know if this format allows that. So if you can type your question into the question and answer screen, or your comment, I definitely appreciate comments too. Okay, I'll wait for that, but then I will go back because I think this is kind of interesting. Job references. So for employees, if you're an employer of employees, and you give a good faith job reference, then there's a statute that says that you can't be sued for defamation or libel. You can't be sued for anything for what you say about your former employee if it's in good faith. And if you're not lying. For independent contractors, there isn't a statute that says that. So you probably have less legal protection if someone calls you to talk about your independent contractor. There's defamation, there's libel, and then there's also a tort in New Mexico called intentional interference with business relations, with business dealings. And so that person could say, you're interfering with my business dealings by talking bad about me to my future potential clients. And so you could find yourself in court for a job reference for an independent contractor more easily than an employee. All right. Does any paperwork filing differentiate you as an employer or contractor? So it is a scheme of paperwork and behavior. And so to keep your independent contractor from being an employee, the first step is a contract. And then the next question is there a contract template? There are tons of templates. They're available online. I wouldn't be surprised if they're available through our hosts today. My firm does them. Small business law firms can advise on them or can draft them for you or can provide a template for you. So there are a lot of templates out there. If you do one on the internet, it might make sense to have a lawyer look at it, and the lawyer will look at it and strengthen it and will also remind you, like, your behavior is going to be super important. Filing for an employee is pretty simple because you have to file all those tax forms. And so you have your new employee fill out that I-9 for authorization to work in the United States. You have them fill out that form. Is it a W-4? Yeah. So that you can issue them a W-2 at the end of the year. So the employee paperwork, there's a lot. But the independent contractor paperwork, you have to start with that contract and then maintain it with your behavior. Any other questions? Okay, so if you have follow-up questions, my contact information, I think, is in the beginning of this presentation, and learn more at l4sb.com will also get to me. So yes, you can get with me for questions. And then our hosts of the meeting, let me make sure I get them totally right. The Minority Business Development Agency and the SBDC at CNM. Those are great resources for additional questions to be answered. And I am available as well. And so I hope that wasn't too dry, and I hope it wasn't too frenetic, but I hope we kind of learned some things, and I hope to see you all again.
Yeah, thank you so much, Christina. It was a great presentation. And I will just, Christina already sent me the presentation. I will share it with all the attendees. And of course, this presentation has been recorded. Once I have it, I will upload it to our YouTube channel. So you guys can, take a look at it if you missed something. And yeah, thank you so much, Christina. And just a reminder to everyone, next Tuesday, we will have another webinar from 9 to 10 a.m. So see you, all of you guys, if you're interested, next Tuesday at 9 a.m. So thank you. And thank you, Fran, of course, for always being with us, partnering with us.
Absolutely, my pleasure. It's been great. Again, thank you, Christina. Really great presentation. And Sophia, thank you. Everyone have a great day.
Thank you.
Thank you.
Bye.
Bye.